Hello everyone, and welcome to part 3 of the 3-part series, What is Discrimination and How to Prove It? I am an attorney and a federal employee who has participated in every aspect of the EEO process. In this video, I will discuss retaliation. This is general information and isn't a substitute for legal advice based on your very specific circumstances. If you are a federal employee who wants to learn how to win their claim, like and subscribe below. Now let's begin. What is retaliation? Any actions that a reasonable employee would have found materially adverse. That means the actions would dissuade a reasonable worker from making or supporting a charge of discrimination. In order to prove retaliation, you must show participation in an EEO process or opposition to discrimination. The retaliator is aware or influenced by someone who is aware of your protected activity. Retaliatory action, and a connection between the protected activity and the materially adverse act. The Supreme Court has decided retaliation, even when comprised of discrete acts, must be considered within the cumulative effect of all retaliatory acts because context matters. This means you should include all discriminatory actions, even if they are considered petty, in your complaint and in your investigation's responses. Examples of retaliation include assignments of a more difficult or unpleasant task, increase in supervision, a reduction of resources needed to do your job, interference in the ability to complete duties, discussing EEO activity with other employees, intimidation. Retaliation can occur after an employee leaves the agency. For example, bad employment references, which are not supported by the employee's evaluations prior to their protected activity, is retaliation. Can an internal affairs investigation be retaliatory? Absolutely. The EEOC has determined that the initiation of an internal affairs or OIG investigation can be retaliation, but the results of the investigation cannot be challenged as retaliation. Once you make your claim for discrimination, the agency will provide the court with a legitimate non-discriminatory rationale or an explanation for their actions. You will then need to show that the agency's explanation is a pretext, an explanation provided to hide the real intention or state of affairs. How do you prove pretext? Show the reasons given are untrue or contradict your prior explanation, violate agency policy, federal law, or customary practices. The events happened not long after the participation in the protected activity. There were discriminatory statements or references to the EEO activity when the retaliation occurred. Tips to keep in mind. Keep track of the date of every aspect of your investigation that involves management or the responsible management officials. Retaliation often occurs when management learns about the complaint, when they respond to the investigation, and after failed mediation attempts. The sooner the adverse action follows the protected activity, the stronger the presumption that it was retaliatory. Document everything with email. Report retaliation to the EEO counselor, the anti-harassment unit, and senior management using email. In all situations, be polite and professional. Keep doing your job well, and don't break any rules. Thank you so much for watching. I hope this video makes it easier for you to participate in the EEO process. If you have questions or comments, please share them below. If you are new to my channel, don't forget to like and subscribe. Goodbye for now, and I hope you'll join me for my next video.